Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing a recent Supreme Court decision about when an internet provider must disclose the IP address of a user to police. The case is called R and Bykovets, and it began with an investigation into online fraud at a liquor store. Initially, during the investigation, the police requested that the store's payment processor, Moneris, give them the IP addresses associated with suspicious transactions. The police did not have a warrant, but the company gave the police the IP addresses anyway. The police then got a production order compelling the internet service providers of those IP addresses to disclose the subscriber information associated with them. If you follow, this essentially allowed the police to match the IP addresses of the fraudulent purchases with the names of a specific individual. That individual, the accused, was then convicted, but he argued that the police had violated his privacy rights by seeking the IP addresses from Moneris without a warrant. The Supreme Court agreed and held that IP addresses are protected on privacy grounds. Police require judicial approval, a warrant, before seeking the IP address. As a result, the conviction was quashed and the court ordered a new trial. Here today to discuss the case are two experts. Nadine Toddy is a lawyer with Borden Ladner Gervais, and Vibert Jack is the executive director of the BC Civil Liberties, litigation director with the BC Civil Liberties Association. Thank you both so much for joining me today. First, I don't want to get ahead of myself on this explanation of the case, and the question in the case is whether or not police need to get an IP address, a warrant before they get an IP address, but. Just to get to basics, Nadine, can you explain what an IP address exactly is and why a person may have a privacy interest in it?
Sure. Thank you for having me, Christine. So, an IP address is essentially a string of abstract, unique numbers that are assigned to a device participating in a computer network, and is typically assigned to an individual by an ISP, an internet service provider, and it's essential to access the internet itself and to send and receive data. So, to answer the second part of your question, privacy protections in Canada find their source in Section 8 of the Charter, which I'm sure we'll cover more in the next few minutes. And there are generally three types of interests: privacy interests, a personal privacy, which follows like bodily integrity and such, and territorial, which is more, we're placing limits on the right to intrude on another individual's environment, and informational privacy. So, of course, this case relates to informational privacy in relation to the disclosure of an IP address. And so, in determining whether someone has a privacy interest, we look at a set of factors, including whether the subject matter, what is the subject matter of the alleged search, the claimant's interest in the subject matter, whether the claimant's subjective expectation of privacy, whether the claimant has a subjective expectation of privacy, and whether that subjective expectation is objectively reasonable. And so, we look at all these factors, and if the conclusion is that the person has a reasonable expectation of privacy, in this case, for example, the IP address may reveal personal information. So it's not unreasonable for one to think that they may have a privacy interest in it. And so it's a highly contextual analysis, but it's important to note that not all information that an individual may wish to keep private necessarily benefits from Section 8 protection.
And Section 8 in the Charter is the protection against unreasonable search and seizure.
Exactly.
So, Vibert, is there anything you want to say there about why you might have an interest in a privacy interest in your IP address, or anything you want to add about the background of this case that I might have missed in my short summary there?
Yeah, so I think Nadine did a great job of covering it. I would just emphasize that due to the way the internet works, it is impossible to use the internet without an IP address. Everyone always has one, whether you're on your computer or your smartphone. And because it's a unique identifier, again, the internet service provider always can tie your internet activity to that IP address that you have to be using.
So, one of the things that really stood out to me is why we didn't have an interest in this before now. Nadine, only about 30 seconds. This is new, right? Why did we not have a privacy interest in IP addresses until now?
So, I mean, it's a great question. I think it's important to raise that in areas that are impacted by technology and AI, which privacy law is,
Hmm.
it's an ever evolving area of the law that has to continuously
Yeah,
adapt to the ubiquitous privacy risks that we constantly face. So
absolutely.
I think the outcome here
Let,
was
let's
really,
let's just quickly take a break and we'll be right back.
yeah.
Welcome back to Canadian Justice, where we're discussing a recent Supreme Court decision that found that police need a warrant if they want to get your IP address. And we've been talking about why we did not have a privacy interest in IP addresses until now, even though it can be used to identify you. And it's sort of required if you're going to be online. You will have an IP address if you go online in any way. So, Nadine, you were explaining why you think we didn't have this privacy interest until the court gave this decision and how this is an evolving area of law. I just wanted you to be able to finish your thought there.
Yeah, so I just think that this outcome was most likely in response to the disruptive innovation and technological developments that we've seen over the past decade, and especially since the pandemic. And so everyone in the legal profession was kind of forced to adapt in the past few years and become more comfortable with using technology. So I think the majority here was very attuned to the challenges that come with that and decided it was time for a more protective approach to privacy rights.
Vibert, what do you think? Why do you think it took until now that to find this privacy interest in IP addresses?
Well, part of it is also just, the way the law works. You have to have a case that comes to the court that raises the issue. And the last big Supreme Court case in this area was Spencer. And you mentioned that the police had to get a warrant in this case to get the subscriber information, and that's because of Spencer. The Supreme Court said that that was necessary. But in that case, the IP address was collected by the police over a peer-to-peer file sharing program. So essentially, the accused had given their IP address directly to the police in that case, and so the issue just didn't come up there. So this is the first chance that the Supreme Court has had since then to tackle the IP address itself.
So Nadine, a question that I have, and look, I'm not a privacy expert here, but like many Canadians, I get ads for things like free VPNs, and a lot of teenagers will even install VPNs on their phone or home devices, which essentially operate to hide their IP addresses. So it's very common knowledge among many Canadians that you can use something like a VPN or a proxy server or a Tor browser to hide your IP address if you want to do that. And often it's not done for nefarious purposes. It's sort of well known that your IP address is traceable to you. So to me, it sort of begs the question of if your IP address is so traceable and so easily identifiable, why would you have a privacy interest in it?
Right. And it's a great question. I think what the majority here said was basically that the IP address is a digital breadcrumb that leads the police on the trail that eventually leads them to the person's identity. Right. And so while the individual might be able to use VPN to hide their address before this decision, the police could have gone to the ISP and gotten access to the IP address because the ISP will always track your IP address regardless of whether you're using a VPN. And so it's still that they would still be able to identify the IP address associated with certain internet activity. So it might be able to shield you from some online users, but before this case, it wasn't required to get a warrant before getting access to an IP address from the ISP, which now we know has changed.
Any thoughts on that, Vibert, and maybe any thoughts on the fact that it does, as I said, I'm no privacy expert. It does strike me as a little unusual that someone committing a digital crime would not be taking efforts to hide their IP address. So any thoughts on any of that?
Yeah, I mean, I think maybe we weren't dealing with a criminal mastermind here. That might be part of it, but we shouldn't have to go to those lengths to protect our privacy. To use an analogy, if we leave our door and our home unlocked, it would be easy for the police to go in there and poke around, but we expect that they won't do that. We expect them to refrain from invading our privacy like that. So even though we can hide our IP address from the police, we shouldn't have to. We should expect the state to respect our privacy interests. That's what the charter requires of them.
That's a really great analogy there, Vibert. Uh, so the accused in this case, he argued that the request for an IP address without a warrant, Nadine, it violated his charter right to be free from an unreasonable search. So we've only got 30 seconds, but what I want to propose to you to answer in the next segment is how was this a search, especially if the service provider Moneris, they did voluntarily give the police this information after being asked for it. But how can you explain why that constitutes a search? We've got to go to break, but when we come back, we'll discuss that. Welcome back to Canadian Justice, where we're discussing a Supreme Court decision that held police need a warrant to get access to your IP address. Now, in this case, called Bykovets, Bykovets, yeah, there was a service provider, Moneris, who is a online commerce platform, and the police asked Moneris to provide them with the IP addresses for certain suspicious transactions. And Moneris did so voluntarily, even though there was no warrant. So, Nadine, can you explain what actually constitutes a search by police? If Moneris gave this information voluntarily, didn't require a warrant, didn't ask for a warrant, why does that still constitute a search under the charter?
So, an inspection to establish a breach of Section 8 under the Charter, a claimant has to first show that there was a search or a seizure and that the search or seizure was unreasonable. And only the first requirement, whether the request for an IP address was a search, was at issue here before the court. And an inspection is a search when a person has a reasonable expectation of privacy in the subject matter of the state action and the information that it gives access to. So, to establish that there was a search, what the claimant had to prove is essentially that he had a reasonable expectation of privacy and that the state invaded it. Which brings us to the test, which we call the totality of circumstances test, and it allows us to look at a number of factors. And if you look at the case here, the heart of the analysis was the disagreement between the dissent and the majority about what is the nature of the subject matter here that we're looking at. And of course, the majority found that the disclosure was in fact a search because there was a reasonable expectation of privacy attaching to it, and that it was irrelevant to look at the police's intention to restrict the use of that information.
So, Viber, can you expand on this notion of a reasonable expectation of privacy? Does it always require a warrant? And if not, why not?
Yep. So the reasonable expectation of privacy, as Nadine just mentioned, is kind of the threshold question. If it exists, then you have a charter right to privacy. If it doesn't, then the police can kind of do what they like. It doesn't always require a warrant. The legislatures can pass laws that allow for warrantless searches. In those cases, the charter still applies, and the law itself has to be reasonable, and the manner that the police implement the law, carry out the search, has to also be reasonable. And there's also exceptions that allow for warrantless searches even without a written law, such as exigent circumstances. So if someone's safety is in danger or a crime is about to be committed and the police need to do a search to prevent those things, then they can. So yeah, it's not as if the police have no tools left just because there is a reasonable expectation of privacy.
So, in this case, the lower courts found that there is no reasonable expectation of privacy in an IP address because they said it does not provide a link to or other information about an internet user. To identify who the IP address is linked to, the police require subscriber information from an internet service provider, which in this case they got through a production order. So there's this intermediate step, and obviously this was rejected by the Supreme Court. But Viber, what do you think of the lower court's reasoning here?
I really think it was too narrow of a focus. They in this particular case, yes, the police got a warrant as part of the investigation, but that's not that's not always going to be true. So, for example, in February, the Privacy Commissioner of Canada came out with a report about Project Wide Awake, which is an RCMP project, where they actually purchase information from private third parties that
Hmm.
go online and look at people's social media and make profiles about them. And the privacy commissioner had a lot of concerns about that RCMP program. And so those very detailed profiles can easily be connected to someone's IP address. So looking beyond the facts of this case, I think is why the majority of the Supreme Court went a different way.
Nadine, 30 seconds. Anything to add on the lower court's reasoning?
I would just say that the dissenting judge had a pretty powerful dissent. I would say the judge found the case to be indistinguishable from RV Spencer and concluded that, an IP address gives us access to biographical core information, and that's why we should protect it.
Yeah, so I mean, this case was a close one. It was a narrow decision. It was 5-4. So in the next segment, let's talk about what the majority held and what the dissent found. Welcome back to Canadian Justice, where we're discussing a Supreme Court ruling that held that police need a warrant to get your IP address. So, Nadine, the Supreme Court in this case overturned the lower court's decision and the Supreme Court found there is a reasonable expectation of privacy in your IP address. So, what stands out to you in the majority decision here?
So the majority decision, which was penned by Justice Karakatsanis, found that the Section 8 protects IP addresses, and it described it, of course, as the first digital breadcrumb that leads the state on the trail of an individual's internet activity. And what really, stood out was that the majority found that the analysis at the lower court reflected a piecemeal reasoning based on the state's intention, and that what was crucial to look at was not what the IP address alone reveals, but in combination with other available information, what could that reveal? And so the heart of the analysis and the key question that they focused on was, what are the police really after here? And that was kind of the key question that guided their analysis. And in striking the balance between, combating online crime and individual privacy rights, they thought that that balance has to include a warrant at this stage.
Vibert, anything you want to point to as something that stood out to you in the majority?
Yeah, taking a look at kind of the bigger picture, I think the majority also talked about the differences between the online world and the real world, and how the court needs to take a bit of a different approach online because of the vast amounts of information that are being collected there. And also, the court talked about their concerns related to private companies sharing information with the police, um, thereby really expanding police powers beyond what we should be expecting. And so, I think those were some other underlying concerns that led them to the path that they chose.
So Viber, this case, as I said, was quite narrowly decided, 5-4. There was a dissent, a forceful dissent that would have found that there is no privacy, reasonable expectation of privacy in an IP address. Can you explain their reasoning?
Well, basically, they viewed the IP address as just a set of random numbers, that it doesn't disclose anything on its own, and that some other step is always going to be required to connect it to personal information. And I think I've addressed that idea. I don't agree with it. Um, Essentially, the minority, like the lower courts, took a very narrow view, only wanted to look at the facts of this case. Um, didn't want to do that kind of normative analysis that's required. What, as a society, what do we want to protect? What privacy interests do we should be protected rather than what is actually the
Mhm.
case? Um, so again, I would just emphasize that I think they took too narrow of a view, didn't take that broader perspective.
And Vibert, one last question: is this a win for civil liberties? I feel like I know what you're going to say.
Uh, yeah, it's a huge win for civil liberties. Again, the IP address really is the key that links all of our online activity to our personal identity. Uh, just think about all of the things that you do on your computer, on your phone throughout the day. The idea that the state can have access to all of that
Mhm.
information is very scary. We're certainly very happy that the Supreme Court took the stand that they did.
So, Nadine, is this going to change how companies act? I mean, what would you advise, a client faced with a request now to disclose IP addresses to police? Would you just say the police are going to need a warrant?
So, of course, I mean, I can't speak generally as to how we would advise a corporation because the facts of each case will vary. But corporations now will have to ensure that any request they receive from law enforcement has to be charter compliant. So, ISPs respond frequently, we know, to requests from law enforcement agencies, and they usually volunteer the activity associated with an IP address. And I think this will cause them to pause now when receiving such a request, and they should probably seek legal advice if they're faced with a request and they're not sure whether it falls in this within the scope of a Bykovets warrant.
Hmm.
And this point is very interesting because, as you may know, the charter doesn't apply to private
Right.
corporations.
Yeah.
But what this case did is essentially add a third party to that
Right. Right.
constitutional ecosystem
That's all the
between
time we
the
have.
state
I
and
want to thank you
individuals.
both so much. We've heard today about a new privacy interest that the courts have found we have in IP addresses. Will this change how you operate online? Are you more likely now to want to hide your IP addresses using something like a VPN? Do you think the Supreme Court decision will change how police or criminals operate? You be the judge.